they couldn't get over the fact that it's a Friday morning. So the excitement is just catching up with everybody. Good morning, everyone. Welcome to Sunrise Daily today. I'm Chamberlain. So
it's a beautiful morning from here in Lagos, Nigeria's commercial capital. I'm Kayode Okikiolu.
Do you have to rub that in?
That's new, you know.
Welcome. I'm Ayo Makinde.
welcome back. Well, yes, as you've seen there, Dr. Obi Adigwe, the DG and CEO of NIPRID, joins us next today on the program. Good morning, Dr. Adigwe. Thank you for joining us today on the program.
Morning, Chamberlain. It's good to be here.
All right, now, the world, everyone is grappling to see what can they do to get a solution to all of this. And nothing wrong in Nigeria also joining on that one. But perhaps we should, start with asking you, is there any glimmer of hope about getting any remedy to this COVID-19 that's got Nigeria's imprimatur?
Yes, there is. I'd like to take it, across the entire spectrum, both commodities that are used for preventive devices that help to control the spread, and interventions that potentially will either boost the immune system of patients who are exposed or people who are exposed to COVID-19. And, in fact, possibly a cure. You can't rule it out. When COVID-19 broke out in China and started going round, we at the Ministry of Health, we were charged by Minister Hanire to start to think about what will happen if this comes to our shores. And one of the things we did at NIPRID was we very quickly identified some of the areas where there were gaps. So we had realized that when this hit places like Europe and America, very quickly things like sanitizers, things like face masks and other relevant commodities, where the supply chain for these products were disrupted. So at NIPRID, one of the things we did was starting to look at how we can put forward our resources to ensure that if it gets here, we won't be facing those kind of disruptions. And I think it was shortly after the 27th of February when COVID-19 finally hit our shores that we presented our concept product development of a sanitizer to the Minister of Health. And he directed that we very quickly get a NAFDAC registration and get that product out there. That has been done. The NIPRID sanitizer, very high quality, highest international quality, is out there. Other things we did along that same line were to collate a database of other people who manufacture hand sanitizers, masks, PPEs, and other such commodities that would help disrupt the spread. And based on, collating the data and making it available, as well as sharing NIPRID's formula with other interested parties that wanted to start manufacturing hand sanitizers, we were able to avert the kind of disruptions that we're seeing in countries like America and other places in Europe. Now, coming to the interventions, so things like ventilators, things like disinfectant devices, again, these are areas where, it's clear to everyone that there's a global shortage of ventilators. You have countries scrambling over each other and seizing each other's consignments. Again, sister agencies, took the bull by the horn, and NASENI, who is a sister agency in the Federal Ministry of Science and Technology, developed a prototype, and which they've come to us to say, we have a prototype of this ventilator. How do we now validate this ventilator scientifically to make sure that it is safe for use in humans, as well as can contribute to addressing the coronavirus issue. So we're working with them to validate those ventilators, as well as supporting their disinfectant devices. Furthermore, things like clinical trials. NIPRID has also developed concept notes and protocols for undertaking clinical studies. Now, this is interesting because what we've done is we've developed these particular proposals both for conventional medicine as well as for medicines that have phytomedicinal origin. And our concepts that have underpinned the development of these proposals are of the highest international standards.
Okay, Dr. Adegwe.
NIPRID is one of the most resourced agencies of its kind in this part of the world.
We're going to come back to the clinical trial bit, but when you talk about collating data of all of those organizations that are doing something to disrupt the spread, what's going on with that? I mean, are you comparing notes with other agencies? I know you talked about NACENI. What about all the other agencies? Do you rub minds with them to see how do we get the best out of where we are, what we already have? And is it just, are you leaving it to NAFDAC to ensure standards about those items, for instance, that you've collated, or you just collate them no matter what, then NAFDAC, it's your bit to do the standards?
Well, you must understand the different mandates of different government agencies. NAFDAC certifies, but for NAFDAC to certify as a regulator, for them to certify, they need to make that decision based on data, okay? Now, NIPRID is a research and development agency, and our job is to undertake empirical research in order to collect the data in a format that is acceptable internationally, but can also be used by NAFDAC to make a decision to either give a registration or not to give a registration. And having said that, I think I want to put this on record that Nigerian agencies don't collaborate enough. There is room for more collaboration. I'm very, very pleased that when we had an interministerial meeting, I think it was last week, the ministers of health and the ministers of science and technology, alongside their permanent secretaries and key directors general, had an interministerial meeting last week. And that was a big step in the right direction, because there is a lot of work that's going on in science and tech which could contribute to what the Ministry of Health is putting forward as potential solutions for the COVID-19 pandemic. And I think that answers your question. Incidentally, during that meeting, I think it was about 3 or 4 of the directors generals from the science and technology side who had indicated that they were already working with NIPRID. So that's just to give you an indication as to how pro-collaboration NIPRID is. However, I think I agree with you that there is need for better collaboration so that we can make sure that all efforts are coordinated in getting these interventions to the fore.
Yeah. I mean, they'll be glad, the country will be hugely glad to see that collaboration. I mean, these are scientists, they're professionals in their field. They know how it works globally. No one person develops these things, but we're hoping that it improves moving forward. But could you get back to the point you were trying to make about the clinical trials? Where are we on that?
So just to follow up on the collaboration bit, the scientists working in silos is not peculiar to Nigeria. You know, as scientists or as people who are at the verge of discovering a new intervention, is always a competition, okay? So that is to be expected. But what we found out is that with coronavirus, the way coronavirus has swept across the globe, there is an increase in the appetite for people to collaborate in order to get an intervention as quickly as possible. Having said that, going back to the earlier point I was making, which is about the clinical trials. So for the conventional clinical trials, we already signed a memorandum of understanding with the University of Abuja Teaching Hospital. Professor Ekele and myself, alongside my team, have had several meetings as regards putting this particular clinical trial protocol through and getting a good body of evidence that supports the interventions that are used in Nigeria. For the other clinical study that we're talking about, unfortunately, there hasn't been enough interest as regards funding and as regards partnership, you know, that will enable us move it forward to the next stage. But we're still very hopeful that people will come on board, and that will also kick off.
You just mentioned something that others in your sector have also mentioned, in research have also mentioned, and that is the issue of funding. How much are we looking at when we talk about funding for research and production, getting a product out, for instance, say from the point of concept to the point where the product is out? How much are we looking at, and how deficient are we?
Research is not cheap. Research is definitely not cheap. And what makes it difficult in this part of the world, we have a mentality in this part of the world to only focus on things that are tangible. The outcome of research is not always tangible. So policymakers, people in decision-making positions, people who are philanthropists and want to show a quick result for the money they're giving, politicians frequently avoid investing in research and development because the tangibility of the outcome is not always apparent. And that is one of the biggest weaknesses we have as a people. The funding gap, it's significant. For you to take a drug from discovery all through to phase 4 clinical trials, you're talking about millions of dollars at a minimum. You're talking about millions of dollars. So from discovery, you have the in silico, you have the in vitro, and you have the in vivo phases. These 3 phases make up your preclinical studies. And then after that, you now go into your clinical studies. And in clinical studies, these are divided into 4 basic phases. You have phase 1, which looks at safety. You have phase 2, which looks at some form of efficacy. Phase 3, which looks at the same efficacy, but with a broader population. And then phase 4, after that product has been given marketing authorization, and you now want to collect data about different effects in the general population. And this is a significant amount of investment that's required. Unfortunately, as a people, we haven't learned how to prioritize research and development, and that is the bane of our society.
I mean, you have laid out this procedure and the cost implication, but do we have any drug in Nigeria right now that is at any phase, either discovery or any of the phases you mentioned? Is there any drug in particular at any of those phases?
So theoretically, yes, but I would need to see the clinical trial protocols of several other partners to be able to make a categorical statement. But there are different therapeutic agents which data has indicated from other settings has activity against coronavirus. There's remdesivir, there's hydroxychloroquine, there's ritonavir, and a plethora of others. However, you cannot use the data from other settings to make a decision in your own context. You need to undertake studies using your own people and subjecting it to your own contextual peculiarities. And I'm aware that one or two other organizations are either at the verge of starting clinical trials or have applied for their protocols to be approved. NIPRID is also at that stage. So for you to even consider putting forward a proposal for clinical trials, it means that the therapeutic agents that you're looking at studying in a human population has shown some indication in preclinical phase, either based on a desk review or laboratory preclinical tests. In both of those different methodologies would have indicated that this has potential for this particular ailment and that it needs now to be studied in a clinical setting for that particular disease. So the theoretical answer to your question is that there are certain agents that have that potential. But what we must now do as a country is to expedite clinical studies of these different agencies, both those that come from the conventional world and those that come from phytomedicinal origin. We need to push these two streams along as quickly as possible so that we can get empirical, incontrovertible evidence of what works in our setting.
Just quickly, I'd like to get clarification. Earlier in the week, we heard that Nigeria is taking part in the WHO Solidarity International clinical trial to get, an effective treatment for COVID-19. Do you know about this? What can you tell us about it?
So a solidarity trial is different from what I've been talking about, because a solidarity trial is you're giving them your own site to undertake clinical studies on a protocol that has been developed elsewhere. There is nothing wrong in Nigeria participating in a solidarity trial for WHO. However, what is wrong is for Nigeria to only depend on WHO solidarity clinical trials. Whilst we're participating in the WHO solidarity trials, we must also, as a country, prioritize interventions that come from our own researchers. We have the capacity. One of the most effective and most popular agents for sickle cell disease, Niprisan, was developed from discovery in NIPRID, in my agency, and progressed all the way to phase 2, phase 3 clinical trials. And this is an agent that's used in close to 44 countries across the world. So we have the capacity. We have the capacity. NIPRID, as I mentioned earlier, is one of the most resourced agencies of its kind in this part of the world. We've won accolades from across the world, centers of excellence, both in conventional and phytomedicinal research. We were the first agency to get both the ISO 9001 and the ISO 17025. In fact, the latest version of the ISO 17025, we achieved it just a few weeks ago. And we did it for the first time in this part of the world through remote testing. I have close to 75 masters and PhDs in my agency. We have a plethora of other professors that collaborate with us from across the country. We developed a quality assurance module for traditional medicine practice, which interns from as far away as Burkina Faso came to attend, and I could go on and on
But
and on.
let me add this so you could let me add this point so you could just respond to it equally. You know, speaking about prioritizing what we've got here, and good to also know that you have those wealth of experience and knowledge in your team. Excuse me. The Minister of Health, we've heard him say several times that certain things or products have been referred to NIPRID. What do you have on the table concerning local herbs or solutions or things in consideration, some of which you've highlighted?
So, NIPRID has a product called Niprimune, which the science has shown that it has immunomodulatory activity, strong immunomodulatory activity. And as you know, the people that are at the highest risk of succumbing to COVID-19 are people who either have underlying illnesses or whose immunity is compromised. So theoretically, a product that boosts your immune system will be an invaluable tool in the treatment arsenal of anybody who is looking at a COVID-19 patient. And this is something that we're now putting forward from NIPRID that can help sort out some of the issues that come up with COVID-19 and also improve patients' prognosis. So this is the key one from NIPRID. However, we've gotten other referrals, like you mentioned, from the Minister of Health. The issue is that I think when people make submissions to the Ministry of Health, those submissions are probably not in a manner that can be investigated. So we're putting together a proper response, which will enable the ministry give claimants a good picture of how they should go about approaching NIPRID for validation of claims. We've put together an entire robust and comprehensive intake process. So when you're coming, what do we need to know about your product? Is it virucidal? Does it retard the growth of the virus? What kind of active ingredients are in it? Do you know or don't you know? Who is the owner of this particular intervention? Because you have intellectual property rights to contend with if that product is seen to be successful. And how many kilograms would you come with if it's a raw material? If it's a liquid, how many bottles should you? So these are things that need to be addressed before we can even start to validate the claim. Additionally, we've put together a group of erudite and eminent professors across Nigeria, so as to give it a national flavor, so that in addition to the laboratory testing that's going on in the 5 technical departments in NIPRID, there will also be a strong national advisory team that will be sort of like peer reviewing the processes before even the data and the evidence comes out.
Sounds interesting. We'll look forward to us doing whatever we can and getting the best hands possible to give us those results. We do thank you very much indeed for talking to us this morning. All right, then. So we will be back in just a moment. We're switching gears now. Don't go away. All right, welcome back. We've got Mr. Fred Nzako here with us in the studios. He's a legal practitioner to weigh in on that matter. Good morning, and thank you for coming on today.
Thank you. Good morning.
We also do have Malaki Ugomadu, who will be joining us via Skype this morning as well. So, but Mr. Nzako, about that particular judgment, where there's been several questions about that Supreme Court's decision. There are those who thought that, was the Supreme Court right, in saying to have declared that Section 397 of the ACJ permits the Justice of the Court of Appeal to conclude a part hears criminal matter on the High Court. So some lawyers don't quite agree with that judgment, saying, wait a minute, they might have erred in law to have gone that way. What do you think?
I wonder why anybody would want not to agree with that judgment, a judgment that is as sound, and as visible as anybody can see, a judgment that cannot be faulted in any way, except you want to look at the issue of society and the societal impact, expectation of the society. But if you're talking law, you can't fault that judgment. Very simple. The analogy I want to give is, if a justice of the Court of Appeal goes back to the High Court to give a judgment, how would he sign the judgment? Every judgment is signed and dated. If he signs it as a justice of the Court of Appeal, will it be valid? No. If he signs it as the judge of the High Court, will it be valid? No, at the same time, because he had become functus officio at the level of the High Court. And if he puts a date that comes after he's taking an oath of office as the Justice of the Court of Appeal, wouldn't he have lied? So, if you look at that analogy, it simply tells you that as beautiful as it may seem, the provision of Section 3967 of ACJA is completely not in consonance with the provisions of the Constitution and even the provisions of the laws that set up the Federal High Court, which is Federal High Court Act. But even if you can say that the Federal High Court Act is at the same level with that of ACJA, or of the Constitution, which is the ground norm.
Are you saying then that the judge who delivered that judgment wasn't aware of this, or he just took advantage of it?
The judge is not only that judge, because they acted based on the provision of Administration of Criminal Justice Act, that's Section 3967.
Yeah.
So, 396 subsection 7. Which requires that, which provided that if a judge has had a matter at the level of the High Court and the judge is promoted to the Appellate Court, which is the Court of Appeal, that the judge can take a leave, which is an administrative fiat from the President of the Court of Appeal, to go and conclude such matters. It's a beautiful provision, but it runs against the provisions of the Constitution. And that in any way and manner, any law runs against the provision of the Constitution, that law becomes invalid to the extent of such inconsistency.
What then was the intendment of that provision in the first place?
The intendment of that provision, very good question. The intendment of that provision was to solve an age-long problem that has bedeviled administration of criminal justice. And what is it? Tardiness and very slow pace of the wheel of justice. A situation where a matter takes off at a point, the judge gets transferred or elevated or dies or just discontinues the matter in any way, manner or form, the matter starts de novo. That means it starts afresh. Assuming, like in Oju's case, the matter took about 11 years. Assigning it back to another judge, you don't know how long it will take again.
So isn't that what's going to happen now?
Of course, that is the only option.
So
and that's the only option.
Means what? The intention was defeated?
Intention was defeated by the clash with the Constitution.
All right. Let's bring in Malaki Ugomadu. He joins us via Skype. Good morning. Thank you for joining us today. I'm not sure, I hope you heard what he said, but what do you think about that judgment now?
Well, first is to thank you for granting me this opportunity to be part of this discussion. It has thrown the legal community into a very conflicted situation in terms of analyzing what has happened, and that is understandable. My friend and colleague will appreciate that if there are no points of divergence and disagreements as lawyers, then we'll be out of business in no time. Now, the point is simple. It is that, and I think my colleague did allude to it, that look, the Supreme Court is not just a court of justice and equity. It is also a policy court all around the world. And therefore, what does it do when confronted with fresh situations such as these, particularly reflecting on the purpose and objective of the law, on the basis of which the appeal came before them in the first place? You would find that the approximately 500 sections of the Administration of Criminal Justice Act 2015 was enacted essentially to deal with the mischief that has beleaguered criminal justice administration in Nigeria, particularly the delay in the dispensation of criminal justice in Nigeria. And that very innovative and creative section 396 subsection 7 is one that was meant to cure specifically the whole delay of criminal trials. Now, the point is rather simple, to say that, look, if the Constitution has granted and specified circumstances in which judges or justices can be elevated and pursuant to which they take their oath of office, you would find that it is the legislation, it is the act itself, in this case, that expanded that constitutional provision. It did not diminish, it did not remove from that constitutional provision. It added to it. And if you take a recourse or a cursory look at section 251, subsection 1, that is the section creating the Federal High Court and its powers, it says that notwithstanding anything contrary to this provision, that this particular court shall exercise the following defined, and in addition, that's the word, that's the key word, in addition to such other jurisdiction as may be conferred upon it by an act of the National Assembly. So the question which I'm posing to my learned friend is this an act of a National Assembly? The simple answer is yes. Has this act expanded by way of addition to the rights and powers of a...
You might as well just come in, because he posed that question to you. He answered the first part of it, but he was going to the second one.
Yes.
So what do you think of that?
Yes. It still has not cured the ill and the predicament of section 396, subsection 7. Remember I said earlier that that provision is a very beautiful provision, but it has to be given legal teeth. And that such legal teeth should not be the one that should be knocked off by the constitutional provision. Because the same section 250 of the Constitution, which establishes the Federal High Court, also makes provision that it can only be it can only have one judge, and that judge should be a judge of the Federal High Court. It cannot be a judge of the Court of Appeal. Neither will he be a justice of the Supreme Court. Neither will he be a magistrate or any other person. It has to be a jurist of the Federal High Court. What you can liken it to is of course, you know that the appellate court has powers to hear appeals arising from Federal High Court, State High Court, Customary Court of Appeal, and the rest.
Yeah, go ahead.
And the rest of them. You cannot say that a magistrate will sit in appeal. You can also not say that a Supreme Court judge, the Supreme Court, will sit on appeal arising from the High Court. There is order. And once you violate that order provided by the Constitution, you are no longer talking law.
Okay, we'll do have him back now. Mr. Gumadu, could you go ahead with your points, please?
Well, I don't know the point at which I was cut off. I understand this network hitches. But the point I was trying to make and to rub it in is to say that what has empowered Justice Idris, Mohammed Idris, to act in respect of a part-heart matter at the Federal High Court was pursuant to an act of the National Assembly. And I've just read out Section 251, subsection 1, dealing with the powers of the Federal High Court, which shall include every other jurisdiction according to it an act of the National Assembly. And I've asked the question, was the Administration of Criminal Justice Act an act of the National Assembly? If the answer is yes, then you cannot be dealing with anything unconstitutional. The second point is that that section, the purpose of which is well known, and my colleague was in difficulty trying to explain how that has defeated the purpose of the act, was to ensure that there is no delay in the administration of criminal justice. And it's not peculiar to Nigeria. In Canada, in the United States, and so many other jurisdictions, this provision appear in similar form. Now, the question he asks can simply be asked. If you are bothered about what the justice will have to sign or append in his signature, as a signature, it will be simple. Even if he mentions Justice Mohammed Idris of the Court of Appeal sitting at the Federal High Court, that will satisfy it. Now, the question to ask him is, what about judges and justices who are seconded or assigned to election petition tribunals? Do they commit unconstitutionality, or will the judgments they pass become a nullity simply because they were probably in the Federal High Court or at the Court of Appeal when they were assigned to the election petition tribunal?
Let me quickly ask you one question before we bring it back. Just one moment, Mr. Gomere. Are you saying that the provision of the ACJA and the Constitution are not at variance? Is that what you're saying?
I'm making that point, and the basis of that point is that the Constitution itself, and I have referenced Section 2.
No, just very quickly, just make that clear very, very briefly. Do you agree that the ACJA, that provision that you have quoted in the Administration of Criminal Justice and the Constitution, do you agree they are at variance or they are saying the same thing? Just very quickly.
They are not at variance. They are not at variance. I've given
now,
you also of which I believe that they are not at variance.
They are not at variance. You say that both of them are saying the same thing.
One has added, has expanded, as it were, and that is permissible.
Now you also said just one moment. You also said that the judge that has been elevated out of the Court of Appeal should have come back to, as he has come back to, he should have appended his signature and said that he was sitting in. Is that permitted in law?
No. I was giving that as an instance in response to the question that he has posed. To say that if he comes and identifies himself as Justice so and so of Court of Appeal is sitting at the Federal High Court as permissible by law, that will not be at variance. It will not.
Mr. Nzako, what do you think of that?
Ipso facto, the Supreme Court justice can as well come down to Federal High Court, sit and give judgment, and append it as Honorable Justice so and so of the Supreme Court, sitting as the judge of the High Court. What is my friend Malaki talking about? I find it difficult to understand his own line of argument. If you mention election petition tribunal by law has concurrent jurisdiction. They are at equal pedestal with the judge, with the High Court. The State High Court and the State High Court and the Federal High Court are of equal pedestal. The very moment a judge of the High Court is elevated, he becomes a justice of the Court of Appeal. And in writing his name, he puts JCA. When he was the High Court judge, he just writes Mr. Idris Mohammed J. Honorable Idris Mohammed J. The Constitution is not foolish by making such distinction. And as much as I said earlier, that the provision of Section 396 of Section 7 is a good piece of legislation, but it runs completely at variance with provisions of the Constitution. So something has to give. So it's either that one gives or the Constitution is amended. So as simple as that.
Is your point that the judge was incompetent to deliver that judgment?
The judge did not have jurisdiction.
Okay. Now, let's bring in Section 16 of the Court of Appeal Act. So they argue that it empowers the court to exercise powers of a trial court as if, the proceedings had been instituted in the Court of Appeal as the court of first instance.
For example, in a matter of election petition at the presidential level, the Court of Appeal becomes the court of first instance. It acts as a trial court, and then Supreme Court becomes the appellate court, and it ends there.
So that cannot be applied in this case?
It cannot apply in this case. It cannot. The Court of Appeal cannot act as a court of first instance in criminal trial that ordinarily should go to any of the high courts, either state or federal, depending on the nature of the offense.
Mr. Ogumadu, do you think that there's a misapplication of that section?
Well, let's look at it this way. By the way, it is not just Section 16. You also have Section 22 of the Supreme Court Act of similar content, vesting powers to act as a trial court, even if it is the Supreme Court. Now, the point is simple, as far as I'm concerned. It is that as a country, where do we intend to go with the fight against corruption, even according to the law? If you look at Section 15, subsection 5 of the same Constitution, dealing with the fundamental objectives and directing principle of state policies, it abolishes all forms of corruption and abuse of power. The same thing is found in Section 88, subsection 2B. So, if the highest court understands the entire gamut of a legislation and the purpose for which that legislation was made, and looks clearly and internally into its own powers as provided by the same Constitution and the Act establishing those respective courts, would it not be in the interest and in advancement of these constitutional projections, ambitions, to align with the efforts of the legislature in trying to bring about that fight against corruption? That is the concern. That is the concern of many who are criticizing the judgment. It is not that the judgment has not been, the ruling has not been given. It is that, well, it has been given, but as a country, and even according to the law, how do we sit? Where do we stand? To what extent has all of the efforts made in the last 11 years leading to the conviction of these people, to what extent has all of those efforts been thwarted by reason of this ruling of the Supreme Court? So, save and until we come to that point where we begin to creatively, and my friends should appreciate that this is a novel legislation. Indeed, it is one of the most revolutionary legislation that has occurred in the administration of criminal justice in Nigeria. And like I said, it is not peculiar to this country. Why is ours very different? Now, if you're going to call as ordered by the court for a retrial of that matter, what you're going to likely find out is that after 12 years running, the prosecuting institution, which is EFCC, has indicated their willingness to go the whole hog. But will that be of...
Just a moment, Mr. Ogumadu. Just a moment. Now he's spoken to what the impression, because remember when he said justice must not just be done. The scenes have been done. So what he's talking about, the impression that people have of this judgment, having spent that amount of time, and then you have to start de novo. They think, look, this is a big blow to the fight against corruption.
Yeah, but that is why we have to get it right. You can't fight corruption outside the provisions of the law. Then it becomes something else. The law has provided for the way and manner you have to fight that corruption. As a matter of fact, it is good that the ACJA is being tested. For every act of National Assembly, until it passes through the crucible of judicial test, you cannot say it has come to stand. And such crucible, at any point, that's why the provision is there. But at any point there is inconsistency with the provisions of the Constitution, that act becomes nullified.
But then you would also agree with those who say that this inconsistency of the ACJA with the Constitution in a way denigrates the judicial process.
It does not denigrate the judicial process, it denigrates the legislative process. It is the legislature that made the law.
But then it also affects
I'm coming.
Just add that to this.
Yes.
It also affects the measure of trust that people have in the judiciary.
It cannot affect measure of trust, except the people don't want to tell themselves the truth. It should have it should denigrate on the measure of trust people have on the legislature. In making a law, an act, you have to, first of all, after making the law, you go back and look at areas of clash and then consistency with the ground norm, which is the Constitution. So that if there is any place where there is clash, you adjust it. The problem we have is that not many people who are learned in law and lawmaking process are in the National Assembly and the state legislative assemblies. So, the state assembly. So what we should, going forward, is Nigerians must think deep. Who do you send to go and make laws for you, so that you save yourself this embarrassment after some time?
Mr. Ogumadu, what do you say to those who think that this provision, this contest we are having over this judgment is affecting the trust deficit that they have in the judiciary? What do you say to them?
Well, that comes to me as a rhetorical question, because it draws its oxygen from all that I have been saying. I recognize that that is a ruling of the Supreme Court, but we're also at liberty to air our view regarding judgments of court. And that is precisely what we are doing. It is a drawback. There must be a way by which a society shows its resentment to the malfeasance of the society, to the transgressions of individuals, and collectively, as a government, as a people, deal with those kind of inadequacies. In my view, if the same Constitution has stipulated that an act of the National Assembly can add to the powers and jurisdiction of a court and not diminish or reduce it, then there is nothing unconstitutional about it. If the same Constitution recognizes that as part of its fundamental objectives and directive principle, as provided under Section 15, Subsection 5, like I said, repeated in favor of the National Assembly under Section 88, Subsection 2B, then such a Supreme Court must rise to the occasion. Now, what do we therefore do? How can this amendment he's talking about be made? What will be started there that will not, in the understanding and reckoning of this present Supreme Court, run foul of the Constitution? Once there is a leeway, and that leeway is found in the sections that I've just mentioned, 251, Subsection 1, Section 22 of the Court of Appeal Act, and, Section 16 of the Court of Appeal Act, and Section 22 of the Supreme Court Act. Once you have such leeway, a court of justice and a policy court must find a way to lend credence and give effect to the intentions of the draftman. That is to ensure that we don't expose ourselves to the people, because justice takes a flight. It takes a flight not at the point when you lose a case, but at the point where the public, where the ordinary man has no longer confidence in what you're doing.
And clearly you don't think that is the case, do you?
Well, I don't agree with him in that case.
Well,
absolutely.
That's why they're lawyers. They always disagree with themselves on these matters.
I don't agree.
So there you go. That's how far we can go with this. That it's always a matter that will always continue out there. We do thank you for coming on, Fred Nzako and Malaki Ogumadu, both of them legal practitioners. We're back in a moment. Stay with us. Welcome back. Yes, Mr. Marcelo Okeke joins us now. He's an economist, the former chief economist with the Zenith Bank. Good morning, Mr. Okeke. Thank you for joining us today on the program. Well, this has got to do with the decision of the House of Reps. They say they are putting up an investigative committee alongside some of their other committees to liaise with the DMO, Minister of Finance, as to the state of some Chinese loans. In fact, bottom line is they are not happy. They say they've been in the dark and they want some sort of either renegotiation or cancellation of some of these recent Chinese loans. Now, from your economic perspective and having followed through some of this things for a while, what do you think is going on here?
Thank you for that question. Like you introduced me, my name is Marcelo Okeke. Really, given what is happening about Chinese loans to so many African countries, it is correct that our legislators are getting worried about what is going on. So many African countries are already in trouble because of the quantum and varieties of loans they have taken from the Republic of China. For Nigeria, as we speak, I don't know who knows exactly how much we have borrowed from China. Maybe in the past close to 2 decades. I don't know who has the figure. But from reports that come out on a daily, on a weekly or monthly basis from various sources, there's cause for concern. Not only in terms of the volume, but also in terms of the variety and spread. Because it's like the only thing we hear these days is China here, China there, China everywhere. Now you are seeing them, the Chinese, also almost everywhere. They are becoming ubiquitous to the extent that you now start having Chinese citizens in Nigeria being involved in fraud or in fraudulent activities.
Yeah, but Mr. Okeke, if I could jump in and ask you this. Now, yes, those concerns are understandable. But the thing about this is, if the House of Reps is thinking this way, one then wonders, they have several of their committees who, on several occasions, have invited different public officials who are in charge of administering some of these loans, and they've interfaced with them. They know how some of these things happen. And besides, these loans were not forced on us. We requested, there was a negotiation, agreement signed, even though they say it's in Chinese, but we understand it was clearly in English. But when you then sign these agreements, how do they then turn back and say no, as though it was forced on us, as though we had no choice in the matter? Can that be the case?
I wouldn't want to say that is the case. But you know, not everybody is an expert when it comes to putting together, the agreement as relates to loans. We have seen that in the past in this country. For so many years, even under the military, Nigeria being in debt trap. They were Nigerians that signed those documents, and yet we entered into a dirty arrangement. And so it's like that is what is playing out again. Because if while our oil is flowing and the petrodollar is coming in, and for almost everything, we'll be running to get loan from China or elsewhere, then it raises serious questions. What's going on? Having said that, I want to say that, there could be human angle to the whole scenario and challenge those who represent Nigerians or who represent Nigeria in signing those documents. Why will, but let me also tell you, if signing of loan agreement could go wrong in other African countries, I don't see why it cannot go wrong in Nigeria, no matter how careful we try to be. Maybe there's the problem of trust of the experts, in quote, in Nigeria and some of these African countries who signed these loans. Because some African countries are already in trouble with China now. And that's why you're having the concept of whether China is recolonizing African countries, and so on and so forth. So if it can happen in some other African countries, it can also happen in Nigeria. And that is the worry we have now among Nigerians and the legislature, the Federal House of Reps, is founded. There's reason for that. There's reason for that. Thank you.
I mean, these loans were not forced on Nigeria as a nation. It wasn't as though we just sat down and the loan happened to us and we thought, oh, okay, no problem, let's tap into this. It is a product of negotiations, I mean, a long process. It's a major thing between two nations, not just between two individuals. And, you know, when you were talking about who knows how much that figure is, the DMO releases these figures from time to time. And as of December 2019, Nigeria's total external debt stock from China Exim Bank is at $3 billion. Now, the House of Reps is trying to review this, and the big question is, what are the possibilities? Is this even feasible? Because this is a lot of money. Is it possible to say, let's cancel it outright or review the terms at this point?
Thank you. It is a complicated situation because each time a country takes a loan, you know, there are processes and procedures for arriving at, you know, the loan being disbursed. Like you said, it is country to country. But at the end of the day, it is human beings that will represent Nigeria. And it's also human beings that will represent China. It's not as if all of us Nigerians will troop to go and sign, you know, the agreement. So that being the case, I am saying it is difficult to now begin to go against or renege, kind of, you know, the terms and conditions on which those loans were given. Because there will be provisions, you know, for punishment should any of the two parties, you know, either discard, reject, or renege on the terms and conditions. But again, you also have to look at, you know, the implications of the cancellation of those loans now, or the possibility of altering their terms and conditions, you know, vis-a-vis any time in future when Nigeria will be unable to pay. I'm sorry to say that. Because the mainstay of the economy, which is oil, is now in trouble. The price of oil used to be very high, up to 60, 70 early this year. But as we are speaking now, you can't even say exactly what it is, whether it's $10 per barrel or $12 per barrel or $30 per barrel. You know? So going forward, how do we pay? And so, if there's anything that can be done now to pull us out of that entanglement, to pull Nigeria out of that entanglement, I think it's still better. Because
No,
the
but
story
Mr.
we are
Keke,
hearing,
you know,
yeah,
if somebody from China were to listen now, they then ask, wait a minute, are they supposed to buy this argument of ours? For instance, the point that you just made as a reason to allow us cancel that loan? Is that supposed to be the way it is? Is this tenable from that perspective, you think?
let me tell you, it's not going to be an arbitrary action. It is the best interest of Nigeria that they go for renegotiation. It's a relationship. See where we are now. See the challenge we are facing. Coronavirus has crashed every economy, especially that of Nigeria, that is a monoproduct economy. Is it not better for us to find a way to renegotiate with China or Chinese so that we pull out of this situation before it gets too bad? That's the point I want to make.
Now,
Should we
if
not
that
pull
were
out
the
now?
case, pardon me, if that were the case, should this be the way we should be going about it, trying to maybe like use the word bully them to allow this to happen? Why don't we just come out the way, better ways, say, listen, this is a huge challenge here, so let's come up with more creative ways and marshal our points properly such that we could both see reasons why we could renegotiate this debt. I mean, it's done globally. But this way, you think this way will work?
Well, the Federal House of Reps is just initiating an action. The process is commencing, and they have mentioned the various committees that are going to work together and the liaison with the physical authorities, including the Management Office and the Federal Ministry of Finance and Budget and Planning. So it is a process that is just starting. So we're going to see how it works out. But I'm telling you that from what we are seeing now, in terms of oil being next to nothing, in terms of its worth, any process that could lead to bringing down Nigeria's huge debt, because it's like China is our greatest, creditor now. Only the Exim Bank of China, is Nigeria's biggest bilateral creditor. In the past almost 2 decades, they have given up to $6.5 billion US, which is about 2 trillion to this country. So anything we can do now that oil is becoming almost nothing, to reduce the volume and value of debt, it is
there are concerns.
It's accepted.
Okay. Just one moment. There are concerns that I'm sure you are also not unaware of, a debt burden and the debt servicing burden. And a number of people have said that this can go as far as 20 years from now. But if we were to go the tangent of this renegotiation with China, what are the bottlenecks you see, and what are the things that you think Nigeria can bring to the table for a favorable resolution?
Okay, thank you. The taste of the pudding will be in the eating. Now that the Federal House of Reps is commencing something new, it will be a real life situation. So let's see how it plays out.
No. Speak to us as an economist. Speak to us as an economist. If this negotiation was to go on and you're part of a delegation to negotiate on behalf of Nigeria, what are the bottlenecks you see? And what are those things that you think Nigeria can bring to the table? Let's say the House of Representatives goes ahead with this. What are those things that you expect to play out? What are those things you expect Nigeria might bring to the table that would make China say, okay, we agree?
Is an international relations thing. Nigeria versus China. How it plays out, I won't start mind reading now. But the truth is that Nigeria is not in a tidy situation to continue to, carry the kind of debt we are carrying. I said earlier on that anything we can do that is lawful to reduce the volume of debt. When they go to negotiation, I don't know any country that has done that with China. If you know what is happening in Zambia now, where almost every public asset is being taken over by China because of the volume of debt, that country is owing China. We don't want to get to that situation. So if our House of Reps initiate a move where China and Nigeria, can sit round the table and discuss, and China is, amenable to our suggestions or our plea with them, okay, I'm fine. I don't see any hitches, because when those things were discussed, human beings were going. The same people who go to negotiation, placing
Let's put it this way.
Situation.
Now, Mr. Okeke, could you then tell us, what would you like to see moving forward such that some of those scenarios you painted in some of the other African countries, even though they didn't force them to accept the loan too, such that we'll avoid those scenarios here?
Thank you so much. What the Federal House of Reps has initiated, the alarm they have raised, is a good one. That could preempt a worse scenario in future. And I am saying, if they now prevail on the executive or work hand in hand with the executive and something is agreed, please let us either stop taking more loans now or negotiate with the Chinese people so that the conditions of these loans are softer. Moratorium, more moratorium, extension, or lessening the conditionalities, upon which those loans were taken. I think anything in this regard would be to our favor, rather than, folding our arms and waiting to be, one of
But
the Southern African countries, basically Zambia.
If we're going to do some of those things, isn't it better that we go with points according to the agreements that they can listen to? For instance, when they talk about them coming with their workmen or doing the contract themselves, we shouldn't also forget those projects are always, if not all the time, specifically project tied. And then secondly, are we going to discountenance the nature of EXIM loans? Even if Nigeria to give an EXIM loan to any African country, it is Nigerian companies that will do the job. The same thing the world over. Are we factoring that in as well when they make the point that, well, Chinese people are the ones doing the contracts?
I want to thank you again, but let me tell you that given what coronavirus has done to the world economy, by the time it is over, my brother, you're going to expect a new world economy, including a new Nigerian economy. As a matter of fact, you don't know whether there will be oil again. So all these scenarios we are painting may turn out not to be realistic. It depends on what the economy is left of the economy after the coronavirus. And I am telling you that even China itself, is having a huge share of its own problems. And in Nigeria here, things are not bottomed out. The situation we're facing now is that of life and death. And that's why every day what you listen is number of people who are affected or not affected or inflicted, not inflicted by coronavirus. So all these things we are saying, until it is bottom out, then Nigeria will know how strong or how weak it is to even negotiate with the Chinese. That's it, generally.
All right, then. Thank you very much indeed, Mr. Marcel Okokie, an economist and former chief economist of Zenith Bank. All right, so it's time for us to get back to you with some of your feedback in a moment. Stay with us.
Thank you for having me.
All right, then let's take a look at some messages. I'd like to start with this one from Joshua. Joshua Dari says, look, everyone across the globe can see Madagascar's strives to combat COVID-19. This is a result of deliberate funding of research and a clear vision of government. It is a food for thought, not only for Nigeria, but for every nation that's ready to change status. Well, we understand you, but it's not exactly as it seems.
Mm-hmm. Yeah, I mean, well, we'll leave that and go to mails now. See this one from Ugo, BM, Mr. BM Ugo, talking about the ACJA discussion we had earlier, saying the answer to the dilemma is in simply inserting in the 1999 Constitution a provision that will read, now this is something coming from him, notwithstanding anything to the contrary contained in this Constitution or any other statute, and he puts in bracket, now reproduce the provisions of the controversial provision of the ACJA empowering an elevated trial judge to return to his former court to conclude his part-heard case. And the problem is solved. Pronto, he says. Incidentally, there is already one such notwithstanding provision in Section 251 of the 1999 Constitution regarding the jurisdiction of the Federal High Court. cutting down and limiting the hitherto unlimited jurisdiction which the 1979 Constitution gave the State High Court. Whew.
We're not going to hear the last of this in a while. But Dr. Anthony Ude goes back to the issue of CVO from Madagascar. Whether Madagascar syrup works or not is beside the point. After all, the race for cure for COVID-19 has been trial and error, and across the world, with some drugs and compounds initially touted as possible magic bullets in some Western countries failing in clinical trials. So if CVO fails clinical trial, it will not be the end of the world. He says, the critical issue is the confidence an island country in the Indian Ocean with only 6 universities, 1 faculty of pharmacy, and 9 research centers has displayed in defending its herbal syrup, despite knowing that any announcement of a cure will bring it on collision course with several Western nations, the big pharmaceutical companies and their representatives, and would also amount to challenging the unconscious but strongly held ideology that anything good can ever come out of Africa.
So they went the other way, the herbal way. Leave the vaccine for them. We go the herbal way.
Use the pharmaceutical language, phytomedicine.
Okay. Not bad. Okay.
Well, let's look at this one from Babajide Akinremi, who says, the good doctor has said it all. Our policymakers do not fund intangibles, not because they're not important, but because they're too hidden and cannot be used for electoral campaigning. Our leaders and Nigerians in general lack the concept of delayed gratification. We have been conditioned by over 50 years of mediocre governance to only see roads and bridges as proof of development. We as a people need to prioritize what is important today and tomorrow. Our leaders also need to shed their myopia for a telescope to see far ahead. That's from Babajide Akinremi.
Well, take a look at this one from Okwoho, who says, I'm shocked this morning listening to conflicting information from PTF. He says, I had watched the briefing some days ago that PNB had ordered for the Madagascar solution, only to hear Boss Mustafa deny that he never said that. I cried this morning for my country. Again, the Minister of Health is denying that they were not the ones that invited the Chinese doctors to Nigeria. Why? Why are they making a fool of us all? Well, that's what he thinks. Or maybe it was out of context, as they will tell you some of these things. But there you go. Keep your opinions coming through. We'd love to hear from you. But that is the show today, and what a week it's been. We'd like you to ensure that you take good care of yourself and each other. I'm Chamberlain Uso.
I'm Kaido Kikyolu.
I'm Ayo Makinde. Have a wonderful day.
And I'm Maokwe Ogun Yusuf. Thank you for watching.